Hello, welcome to Law Unplugged. Today we are blessed to have with us Mr. Faisal Sherwani, sir. Sir is a partner at Luthra and Luthra Law Offices. He's also an advocate on record at Supreme Court of India. He's done his LLM from the George Washington University Law School and has a lot big mix of experience over here. Let's start the interview with him. Okay. So, sir, the very first question to you.
Yep.
Please tell us how did you enter the field of dispute resolution specific in it, and how what was the most interesting part that excited you here to enter this one?
You know, I think the taste that I developed, the passion which I had, or which I have, and indeed the field which I sought to enter, if at all, was law. And I say this in the more traditional sense, the sense in which the legal profession has been understood through the ages, through history. And once you remove the bells and the whistles, actually, the niche practice area, so to speak, like dispute resolution, like M&As or regulatory areas of practice, they're really more of recent origin. And I think they were adopted, from the foreign format, from foreign firms, so that, you could cater better to your foreign clients and their needs and the high net worth clients. Uh, and these are all jurisdictions where the practice of law has evolved into heavy specializations. So I think the taste which I had for law really was, and it started from somewhat of an early age, maybe. So after my basic schooling, I did develop, an instant fascination for political thought, for diplomacy, history, and economics. I was drawn to the writings which advocated free speech, liberty, freedom of religion, thought. And therefore, sort of think of it naturally, I was drawn towards law ultimately. When I read about the great political thinker, I think higher secondary school maybe, John Stuart Mill, the great British free thinker, where he compared, silencing one individual to robbing the entire human race. At that point of time, I thought there was nothing more powerful. And when you believe in those fundamental liberties and freedoms, I think you would naturally be drawn towards something like constitutional law, and that is what happened to me. Uh, but coming back to the issue of specialization, since you raised the issue of dispute resolution, somewhat interesting. Uh, I think it is indeed important to specialize. I think it is the future of law also in many ways, the future of the practice of law. But I think it is necessary to do a little bit of everything before you decide, to channel your energies in one direction. And I think dispute resolution gave me that freedom. It even presented a certain amount of respect for my intellectual pursuits. It was more diverse. I could do more things. It would be a more rich experience, I assume, rather than being tied down to one particular area of law. And I would lose my own individuality in the process, just because some big law practice or some big law firm wanted me to, channel all of my energies in one direction. I think that is why I chose dispute resolution. But it's a common misconception that a dispute resolution lawyer cannot specialize in a particular area of law. In fact, most dispute resolution lawyers, we fancy ourselves as specializing in some area of law or the other. And many of my colleagues will attest to this sentiment. But we're a bit more durable and flexible, that we can cater to a client, and his needs, which may be, detached from the area which we most love. And I think that is something which is possibly a little distinct from, a core specialist who will virtually exclude every other thing than what he does. And I think to that extent, those were the reasons why I chose dispute resolution. If you've heard of him, there was Lord Henry Brougham, the great British statesman. He qualified as a barrister in the 1800s, mid 1800s, I think. So he famously said, a lawyer must know everything about something and something about everything. And I think what he had in mind was a dispute resolution lawyer at that point of time. He must have, because back then those niche areas of practice in the 1820s, 1830s, when he must have said this, they were still unknown or not commonly known at least. And I think I followed that path. If that answers your question somewhat.
Wonderful, sir. What I find is, sir, you always like you always try to explore everything and then you found it out over here.
I
Wonderful, sir.
think that how it happened. I think that is how it happened. I had a thirst for doing diverse things. I found that to be more enriching. And then this was that area of law and practice which would satisfy those desires. I think that's why I am where I am.
Yeah.
Sir, so can you please demystify the entire process from when a client walks in for a case and how this whole process of dispute resolution works?
Hand on heart, I wish I could say that, it were an activity which is so seamless to be referred to as a process. But I'm afraid in reality, it's all a bit detached. You find yourself wearing different hats through each step of this process, each step of this detached process. That of a patient listener to your client, hopefully a wise advisor to him, as a counsel to him in court, if that is what it's going to be. And quite properly, if you were to write a book of it, I think you would dedicate separate chapters to the different bits of this process, if not entirely different books to begin with. But I'll tell you, a good dispute resolution lawyer, I mean, he should, in the vast majority of cases, attempt to look for an avenue which saves his client from, having to expose himself to an expensive litigation. Now, this might seem completely antithetical to a young lawyer who believes, that he needs to make money quick and fast. But remember that you will be known for your approach, among your clientele, and that reputation sticks. And you will be doing yourself a favor if your client, they know you for getting them quick and inexpensive victories. And trust me, the word does get around. And I think you should make an attempt to always see if there is a possibility of amicable resolution before going to litigation. You should exhaust all means of peaceful resolution. If the parties have agreed for, let's say, a formal means of dispute resolution like mediation or reconciliation, they should be resorted to. And once a litigation starts, unfortunately or not, you can actually compare it to maybe a game of poker where you put in some money and then your opposing side puts in some money, then you raise the stakes and he matches it, and then by the end of it, by the time that the matter comes to culmination, both sides have put in so much money that it is not possible for them to back out. And therefore, you will see that the vast majority of cases, by the time they are settled, they're actually early stages. You can't really afford to back out at the later stage. I think that's how I would put it. And each stage, I think, of the litigation, I think how the work is allotted is the least interesting bit of it. And how litigation progresses is the most unpredictable. So in a firm structure, possibly you could say the paralegal will do the little tasks, he'll be running around or she'll be running around. The associates and the senior associates will be scribbling notes and going through hasty research. There will be somebody mid-level between a partner and them who will be managing all of this, somebody like a principal associate. The partner will possibly be or should be the face of the firm, nurturing the relationship with the client, taking the strategic decisions and calls. And hopefully, if he has a spine, he should be taking the blame for all of it if it all comes down like a pack of cards. So that's how it progresses, and it depends what kind of litigation it is. Is it an original matter? Is it an appellate matter? How it unfolds is largely unpredictable in our country, in our scheme of things.
Right. So moving on to the next question, I've been hearing this or I've been reading this that law firms, even the top law firms, are hiring outside counsels or the concept of counsels is there. So I mean, they do the grunt work or and they hire some outside counsel to actually go into the courts. So why is that? But also, what I've been hearing is that now it is changing. So law firms are encouraging their homegrown team of litigators who will actually go to the courts and fight it off and win. So how is it changing and why?
Yeah. So I'll answer that in two parts because there are two possibilities to that question. But let's talk of counsels for a moment. While I have worked at a firm which I've actually never worked at a firm which relies on off counsel. I'll tell you that straight up. Assuming that I have worked at a firm like that, at least I was not part of that exercise. I would take offense to it, right? But I know of the practice, and I assume it is changing because the model, really, truly speaking, it's entirely unsustainable. You think about it. If you were to run your own firm, would you like to reduce it to a mere post office, where the client waits and he is served coffee? Well, we can do that, but if that's the only thing that is being done and that it's a place where papers are posted and they're delivered to some other council outside your four walls, so that some other council can ultimately apply his mind and advise the client, then that is probably not how you would like to, in an ideal utopian sort of a situation, run your firm. And sooner or later, many clients will realize that they're having to pay two sets of legal fees, right? And the contemporary day client is a rather smart one. If he thinks that he can do without paying one set of fees, he will most certainly explore that possibility. And therefore, you must be able to add value to your client in the most traditional sense that a lawyer can and should. The classical concept of the lawyer, and I think I said this, the patient listener and the wise advisor, the upright counsel, that concept is as old as the profession itself. And if you cannot inspire that amount of confidence in your client, and if he feels the need to have to go somewhere else to some other counsel, to satisfy those very basic needs, then he probably shouldn't be with you in the first place. And therefore, I think that is why it has to change and it will be changing, because if you rely on that model, I, as a client, once I figure out what's going on, I wouldn't want to be with you. But having said that, and this is the second part of what I was talking about, you can, and I think the profession does make place for, in fact, by statute, it makes a place for senior advocates. Okay, now that's a little different from the concept of an off counsel. A senior advocate is your Indian equivalent of a barrister, right? So let's say you have a high stakes matter and you want a particular counsel to appear for you in court, so to speak, the gladiator of the arena who will actually pitch your case to the bench. Now, I would be very uncomfortable. In fact, I would take offense if you were to say some off counsel is going to argue your case. I'll say you take your brief and you go to that off counsel. But if it's a senior advocate of some years of standing who has got greater experience at the bar and has a greater knowledge by virtue of the number of years he spent understanding that subject or that area of law, then by all means you can brief him and engage him and make him understand your perspective, and he can go and present that case to the bench. But yes, of course, that's quite different from having an off counsel, and therefore those big senior advocates which you have and which you read about, uh, I think there will always be a special place for them in the practice of law. You can't completely do without them. In fact, that is something to aspire to. If you have a taste for, arguing your matters, being a courtroom lawyer, if that is your natural habitat, that's something to aspire to. Maybe someday you should have your own counsel office in that sense. So that is somewhat detached from the concept of an off counsel. I think that can still, you can make some place in your heart to continue with that practice.
Yeah, wonderful, sir.
Great. I guess that has been really insightful of you to have cleared all our misconceptions and all our questions. So moving ahead, yeah, thanks a lot. You see, there are I heard this in some interview. Some lawyer was saying that there is a lot of competition in courts and there is a lot of they struggle to get cases, and so there are many fishes in the pond, so it's really difficult to make a mark for oneself. So your pieces of advices to the fresh pass outs and the struggling lawyers who want to make begin the litigation era, the field of litigation.
Well, nobody said it was going to be a cakewalk, right?
No.
It's the practice of law, and yes, there is competition. There is meant to be. I think that's true for any aspect of life. Equally true for law. Um, and yes, the initial years will test you. You may even face some amount of doubt, but I think that's the whole point about a good lawyer. You need to be patient. You need to learn to persevere. My advice to lawyers who are graduating, or law students who are graduating, sort of changing posts, practitioners of law in the early part of their career, I would say you need to change, look at that transition as a milestone. Uh, your Possibly your approach has to be that, look, it doesn't all end here. You need to continue to cultivate, your faculties. You need to continue to invest in yourself. You need to continue to study law. That can never stop. And when I say study law, I mean study it, not read it. There are no prizes for reading books cover to cover. And I say this frequently. My wife says, I've just finished so many books, and I've never been good at reading books cover to cover, quite simply because if you finish a book cover to cover, there are no prizes for it, quite simply because if it doesn't make you think critically, inspire you to critically think. You can finish all the books you want, make no difference. That repetitive sort of study, I think, has to continue throughout. And you need patient. Don't run after money. Continue to be diligent and responsible. Diligence towards the profession, diligence towards your client. This will follow in time. There may be competition. There may be times when you might want something for yourself, but you may not be able to afford it necessarily. But maybe that's how it's meant to be initially. And if you want to make big dollars very quickly, maybe you picked the wrong career, because it's not going to be like that initially. And you might have chosen the wrong reasons. And if you think that there is a lot of competition or somebody has an unfair edge on you, uh, then you can go about crying about it, or you can get up and do something about it. So I think perseverance, diligence, and focus, determination is my advice to whoever graduates from law school and wants to continue to do well.
Right, right, right.
Yeah, yeah. Just to,
Yeah,
fine,
Heman, go
Rajesh.
ahead, go ahead.
And I was just saying that to add on to it, I was just listening to you, and I felt this ki you're not that person who always says that this is destiny or this is what I have meant for. You just person just try. It's like you're telling us to be practical in life, try everything out, and that is what we get it.
Yeah, I think that's how I went about it, and reasonable minds can disagree. Somebody might absolutely take offense to the fact, to my approach, or may disagree about it, and reasonable minds can. I think what I'm saying is this is the way I did it, and it worked for me, and I have no reason to assume that it wouldn't work for anybody else also who chooses to take that route.
Yes,
Definitely,
sir.
sir. Definitely.
Wonderful, sir. Okay, so just before we start with the rapid fire round, just one question I want to ask. So, I mean, it is a very common questions which you would have heard. So, the question is, how should a law student bridge a gap between working in a law firm and education? I mean, many law students think like that. Okay, I've won this moot court competition. I've written this many number of papers. Now I am fit to do work. But no, it is not that, right? So, what is your take on this?
Yeah, so I think it all boils down to whether you treat those publications or your participation in moot court competitions as the ultimate objective, or do you treat it as a means to reaching some ultimate objective. I think that is where you will see that there may be a distinction, and that is why you might disagree with somebody's perspective on it. Uh, why do people look at publications and your participation in moot court competitions and how well you've done academically in law school? I think they're just some amount of indicators. And look, I'm nobody to doubt somebody who does well at academically at law school. In fact, between us, I did well at academically at law school. But I think they are looked at as indicators because it's an exercise in finding passion. I think that is what anybody who interviews you and wherever you will go, that is what people look for. So you may find it in a publication, or you may find it in several publications. In fact, you may have written 10 publications, but I think 9 of them suck, frankly speaking. But maybe one of them will ignite my interest in speaking to you or having an interaction with you. Maybe it's the way you communicate. And when I say communicate, it doesn't mean the way you talk. There are lots of talkative people out there, and there is a common misconception again that if somebody talks a lot, that person should go to law school. But I think that's completely, it never be the benchmark. I think it's more about whether you are able to build a rational argument when you're having a discussion. I think that is the exercise. So all of those little things you might be doing, there is no other way. If you're fresh out of law school, I can't insist on you having X number of years of experience in the profession, right? Because that would be unfair, then I'm an idiot. But therefore, you look at the publications X, Y, Z. But I think the true test is whether you have passion or not. And that's why people look at all of these little indicators. And I think all of that needs to continue. It goes back to what I was saying earlier. There has to be a constant study. You need to continue to cultivate your desire and your faculty, your passion for law. And if you have that passion for law, sooner or later it will culminate and people will see it in some form or the other somewhere. There will be that recognition. It will follow soon, maybe just not when you want it.
Great. So I guess that brings us to the end of the very formal part of the interview, which is
Was it? Yeah.
moving on with the last leg of this interview. This is the on your fingertips round, which we are very proud of because we thought this was a very novel creation of ours in the interview format. So
Okay, let's find
ahead. Yes, sir. I couldn't hear you, sir. Voice is breaking.
Yeah, let's go ahead. Give it a shot. Shoot.
Oh, yes, sure. So the first question being, tell us the most challenging case that you have been a part of.
I think a set of writ petitions which mounted a challenge to various state aggregator rules. There were rules which were framed for regulating taxi aggregators like Ola and Uber within the and under the aegis of the Motor Vehicles Act. It involved constant strategizing, thinking, learning, traveling different jurisdictions and appearing before different high courts. It involved staying away from home for close to 2 years because I was constantly traveling. But any case is challenging in that sense. I just think this one really took a toll on my mental faculties and my personal life. It was challenging in that sense, but it kept me happy, engaged, worried. All of those emotions I associate with those matters.
And also, was it your one of the most cherished cases?
Yeah, cherished in some sense. Was it the most cherished case? Maybe not. So you will realize when you do these matters, you'll realize that maybe your most difficult or challenging case may not be the one that you cherish the most. Maybe there may be some small matter which you may have done for some, some small tenant, or there may be a pro bono matter which you would have done for some poor driver of a vehicle who wanted to be regularized in his service. That might give you more satisfaction. Maybe because it was more early in my career. What I'm talking about was a case which related to a batch of drivers who worked for the Noida Authority, the new development authority. And they were pretty humble chaps, they didn't have a lot of money. They could really not afford a senior counsel's fee. They could hardly afford mine. I appeared for them before the Supreme Court in the hope that they could be regularized in their service of the Noida Authority, because they were all basically on contract, which deprives them of various perks and benefits. And when I was able to get that for them, and I think it was early in my career, maybe the first or second year of law practice, I think I still cherish that to this day. I didn't make a lot of money out of it, but money has got nothing to do with satisfaction when it comes to the practice of law. You will realize that.
Yes.
Right. And that is also what we learn from a lot of movies these days.
Maybe those movies are right then, yeah.
Right, right, right.
Yeah.
Great. So the next question being, tell us any funny anecdote that has happened with you.
Okay. There will be a lot of funny things. In fact, if you start taking everything too seriously in the practice of law, it ceases to be funny. So there is a funnier side to everything, actually. I think one of the funniest instances which I can instantly recall is it has to do with the recent article I wrote also. If you want, it's available on Bar and Bench. I wrote it in the context of having an open court. Why there should be an open court even in the time of a pandemic such as this, where you are not able to attend, the brick and mortar court. And it really has a little bit to do with how the presence of a client changes the outlook of a lawyer when he knows that he's being watched by his client. So I have a friend who's also a lawyer. He's got to be the most laid back, lazy person I know. He practices law not because he has a strong passion for it. He does it because he doesn't know any other way of making money. But he basically drags himself to court every day. But he was arguing this one matter for a policeman who had just been, thrown out of service. And once his arguments were not accepted by the bench, he burst out into, a sort of an argument which was extremely passionate. And this policeman had been, expelled on the grounds that he had consumed alcohol and he had been unfair to his seniors. He had spoken back to his seniors, something which is not traditionally tolerated in police forces. So here this chap bursts into an argument. He makes a passionate appeal to the bench and he says, I think this is all a matter of hypocrisy and everybody enjoys, secretly a peg of scotch. But, in public we ostracize. It turned into that sort of an argument. And ultimately the bench accepted his argument and issued notice to the state and to the police department to see if something could be done for the poor chap. So I look at that episode and I find it somewhat interesting and humorous because when I stepped out of the courtroom, I did ask him, what made you make that sort of an appeal to the bench? I mean, I know you're a laid back sort of chap. So he said, the client was actually watching. I knew he was there. And it was all for his consumption, not so much because he has a passion to argue his brief.
Okay,
Yes.
right.
Okay, sir. So moving forward, name 4 fields which, I mean, as you said, even a litigating lawyer has, he can specialize in some fields. So name any 3 to 4 fields which you would like to specialize in.
I think my taste, and you might pick up from this from where I started really. I do have a passion for and I do love constitutional law really. If I have nothing much else to do, I'll probably be reading constitutional law. That's how it started. So constitutional law, definitely. I have a taste for a subject which is not really taught in law school, unfortunately, and correct me if I'm wrong. It's legislation or interpretation of statutes. I don't know. Are you guys taught this in law school?
Yes, sir.
Oh,
Oh, you are?
4 or 50.
Like, so they're doing you a favor. You will realize that if you know how to read a text or interpret a statute or a text, you're already ahead of the curve. Okay, so it's a very it's everybody thinks I'm what a text means, but that may not be truly so. I also, and this is somewhat disconnected because most constitutional lawyers are not necessarily great criminal law practitioners, and I didn't start off as one. But my time at the firm has required me to start to concentrate on it. And I realized, gradually that it is something that I can learn to fancy. So maybe white collar crime and practice of criminal law generally, the substantive offences under the IPC, the procedural aspects of CRPC. This is all something which I have picked up on and I have started enjoying. But truly speaking, if that one area, if you were to ask me where my heart lies, it's constitutional law. And I think that's the whole point. You can either choose to specialize right out of law school because you want to apply to a particular firm which has already created a niche area of practice, and to get into that area of practice, you need to demonstrate that, oh, I am an IP lawyer or I am a regulatory practice lawyer. I think that's not the ideal way to specialize or channel your interests. You should be able to explore everything and then make up your time, make up your mind gradually. And I think that's how it happened with me. I did everything, and then I realized it's constitutional law really where my heart lies.
Yes, sir. Great. Yeah. Just to ask you one more question, which is the one Supreme Court case which you would have loved to litigate before the Supreme Court? I mean, any landmark Supreme Court case?
That's a good question. Okay, so there's several cases, okay, but unfortunately, I was either not born, or I was still in law school, or the clients didn't come to me. Okay, so
Right.
Keshwanand Bharti, for sure. Maybe the Aadhaar challenge recently
Yeah.
before the Supreme privacy case. The issue of transgender rights, that's an old case which has been not particularly old, but I think early 2000s. It's a judgment authored by Justice Radhakrishnan.
NAS Foundation.
Then NAS Foundation is the judgment on 77, I think. That's what they were concerned with. The transgender judgment is a different one. It concentrates more on transgender rights, those of the eunuchs and other categories, and how they are to be treated as a separate gender. If they don't identify themselves as a man or a woman, but they identify themselves as a third gender, that was something that was recognized by the Supreme Court. It's a judgment authored by Justice Radhakrishnan. I think whenever I read that, it makes me want to have been a part of it. It goes back into Hindu mythology. That's, I think, how he starts. And I'll just take 2 minutes to tell you this, because I think you might want to go back and read that judgment.
Definitely.
When Lord Ram was being sent on his vanvas, right? So at that point of time, there was he instructed everybody there that, you are not to follow me, to the place of my vanvas. No man or woman should follow me. So the eunuchs, they said, we will come with you, and they went ahead with him. They went along with him. On the pretext that they said that we're not man or woman, we're a third gender. And Justice Radhakrishnan rather beautifully puts it out at the top that, this gender of people were always well respected in our country, and they came to be ostracized only when the Victorian concepts of the British were adopted, and laws were framed for them. Because otherwise, if you go back in Hindu mythology, there was always a place for them. So I think it's a delightful judgment, delightful issue of law. It's called National Legal Service Authority versus Union of India. You'll find it by that name. But equally, the 377 challenge NAS Foundation in the second round of litigation is all something that would be right up my alley. It would absolutely interest me. And that's the good thing about having a system of precedent and having the opportunity to go back and read all of them, all of these cases which are well documented and reported by the courts. Because even if you weren't a part of them, you can at least be a part of them later in time when you read them. But yeah, to answer your question, a whole bunch of these cases, but maybe I wasn't there for whatever reason or circumstance.
Right.
Yes, sir. So now I guess, yeah, with this we come to the end.
Oh,
Yeah, yeah.
So I want this to end on a funny note. So I have this one anecdote to share with you all. So
Mhm.
this is of Mr. Harish Salve, and I think he was with Nani Palkhiwala in some mediation matter. Not I'm not sure of the specificities. So
Yeah.
what happens is that Mr. So in while they were in the mediation room, before they entered the room, they were having some conversation which was left in between because they had to enter the room and they had to follow the formalities. So what happened is that Mr. Nani Palkhiwala passes a chit in between of the
Yeah, yeah,
mediation to
yeah.
Mr. Harish Salve. Yeah, so the I guess the mediator asked them that what's the matter? What are you passing the chits about? So Mr. Salve says that Nani was asking if there are some books available, and I said yeah, there are. So later in the interview, he says that what actually happened was that Nani had asked him whether Harish
Yeah,
Salve's wife will have sherry or scotch this evening,
yeah,
which
yeah.
was the
Oh yeah.
conversation they were having before.
Yeah, right, right.
Yeah.
I think there's this on YouTube. There is one show, right? I mean, yeah, from yeah. So where Harish Harvey sir says this, yeah. So wonderful, yeah. I mean, I had seen an interview. It made me laugh. I mean, how can a person of his stature? I mean, in court, I mean, serious court, he passes on shit to. I mean, it just says right. I mean, how. I mean, fun-loving person. Even he loves this. Whatever he's doing.
Mhm.
So I mean, one
I
thing
think
which
that's the. I'll give you my sense on it. The
yeah,
point is that you should,
Yeah.
as a lawyer, you should be open to the idea of satire. You should be able to lighten the mood. Sometimes, even in the thick of a extremely, engaging matter or a serious matter, you should be open to have a lighter moment. I think that is something, that sort of a personality is what makes a great counsel like Mr. Salve or Mr. Palkiwala.
over the last 45 minutes or 1 hour, we have talked about many things, regarding the law, really not relating the law. So, I mean, last thing which I want to say is, again, be it any lawyer, be it a law student, one thing which we share in common is the love for the law. So, I mean, that is what makes such talks very, very funny and, very loving to hear too, right? So, yeah. So, with this, we have to call this an end to this wonderful interview which we had. So, thank you, sir.
Thanks a lot. Great talking to you all. Cheers.